Hi, everybody. I'm Michelle Morris from Consolidated Planning Group. Thank you so much for joining us today. Today we've got a fantastic co-speaker with us, Alison Packard from the Packard Law Firm. And today we're going to be talking about why you need both a special needs financial planner and a special needs attorney. So today's webinar, we should be here for about an hour today. Because we're in webinar mode here on Zoom, that means that we cannot see you or hear you. But with the chat box, we're going to be able to take any questions you have or comments that you would like to share. We would love to see those in the chat. The other thing I would like for you to know is that we do record all of our webinars. And later on today, you will receive an email that has a link to the recording and the slides from this webinar. Whatever email address you used to register for this webinar is where that will go. So if you have any questions as we're going through the slides, please feel free to put those in the chat box. We look forward to hearing from you as we're going through this presentation. So a couple of things first about Consolidated Planning Group. We are a special needs financial planning firm. Almost every single client that we have has a family member with some kind of intellectual or developmental disability. And we put these webinars out as a way to really inform the public and families who have a loved one with a difference in order to let them know what they need to be thinking of and what they need to be doing for their loved ones. So please check out our YouTube channel. We've got hundreds of great educational webinars out on our YouTube channel for you to look at when you have time. I know you probably don't have a lot of free time, but if you ever do, those are for you. So families come to us for help with things like protection plans for their family. Think about what is going to happen if you or your spouse suddenly cannot work anymore, or if they pass away early, if they become disabled themselves. These could really throw the finances for your whole family into a tailspin. We help you think about lifetime care planning for your loved one, transition planning, ABLE accounts, and how to use all of these different buckets of money. And we're here to advocate for you and to educate you, because as you're going to learn today, not every financial advisor, not every attorney is made the same. We are not all created equal. So we want to be this expert for you, kind of in your back pocket, be there to answer your questions and to help you figure out what you really need to be focused on when it comes to planning for the future. A few bits of advice, we do know it keeps you awake at night thinking about, oh, who's going to take care of my loved one when I can't do it anymore? And how are we going to pay for that? Well, we want to encourage you to think ahead, start planning as soon as possible. If you start planning now, you're going to have a longer runway to be able to, make smaller incremental changes and corrections to your plan. And, you can have a larger impact. If you start later, you have a shorter time frame in which to make corrections if necessary and to plan for the future. And it might be way more hectic and annoying and anxiety-ridden planning instead of, taking your time and doing it right. Think about what's going to happen after high school. There are great vocational, educational, and residential options. Waiting lists for these programs can sometimes get kind of long, so please do keep that in mind and tour these programs early so that you can get a feel for what might be a good fit for your family. And finally, be very, very careful when a lot of people think, oh, little Jacob has a sister, Sarah, she's neurotypical. She'll be able to have a job. She'll take care of Jacob when they're older. Well, when Sarah's older, maybe she won't be able or willing to take care of little Jacob. Or might feel like an obligation for her, and you've put her in this position. She might feel a little bit resentful for that. And on the other side of that, Jacob, he's been best friends with his sister Sarah all this time. They've been partners in crime. They have fun, they get in trouble together, whatever. And now all of a sudden, Sarah's trying to take over the role of mom. Jacob might feel a little bit resentful about that too, and kind of have a "you're not in charge of me" attitude. So just be careful. Some people think that that's going to be the answer to all of their problems, and it can create more problems sometimes than it solves. So again, in today's webinar, we have attorney Alison Packard. She's going to be helping us talk about the legal side of planning, whereas I help with the financial side of planning. So Alison, would you like to talk to us a little bit about whether or not this makes you our attorney?
Yeah, no, I'm not a hired attorney. So this is our standard legal disclaimer. Whenever we do an educational program, as attorneys, we just need to remind everybody that I'm not giving specific legal advice for your situation. This is just an educational program to give you some general ideas. But of course, you would always want to visit one-on-one with an attorney, present your particular facts and circumstances to get legal advice.
Fantastic. And your contact information, as well as my contact information, are within these slides. We'll have a slide up that has our both of our email addresses and phone numbers, or whatever info you want people to contact you at if they have questions after this is over.
Absolutely.
All right. So one thing we kind of say is that, as your financial advisor, we focus on the money side of things, helping you with financial advice, with the special needs considerations factored in. So we do everything that any financial advisor would do. If you walk into any financial advisor office, we do all those same things, except we do it through the lens of understanding that your child might not be able to be completely independent. They might not be able to have a full-time job that's going to provide the money for them to be completely independent. So they're going to need your help for the rest of their lives. So we help you figure out how to do that financially. Now, Allison and Packard Law Firm is here to help you with the paperwork and legal side of your life and figure out how to take care of your loved one legally and have that legal foundation under them to make sure that they will be protected. So as your special needs focused financial advisors, Consolidated Planning Group, of course, will help provide financial advice for your specific situation. Everything we do is customized. It's very much just based on your family, your unique needs, and your situation. Financial advisors can be fee-based or commissions-based. We can help you calculate the future cost of care, which is really important because, while you're here on earth, while you're living, we feel like it's part of the parent's budget to take care of their children. And when you have a child with a disability, that is going to, your kids are going to be on your payroll for your lifetime, pretty much. A lot of times when kids are about 20, 25, maybe a little later, they finally get off their parents' dime and they go to their own job in their own place. But when your child can't really do that, they're going to be under your wallet, right? But when you pass away, they're still going to need help. So how can you set aside that money ahead of time to be able to provide for their needs? That's what we help you with. We want to make sure that your money and your assets are in the right buckets so that it does not jeopardize your children's benefits. You wait so long for these state waiver programs. There are great federal benefits available to children with disabilities. You don't want to accidentally do something that's going to take those away. We can look at your current assets and help you think about your ability to retire and still be able to provide future care for your loved ones. When you have a loved one with a disability, it's not just you and your spouse's retirement you have to work on and worry about. Your child's future is kind of like a third bucket of retirement that needs to be filled. And we help provide advice on which financial vehicles are going to help your family reach your goals. What does that look like for you, and how does that work? We look at protection plans, like I was talking about. What happens if you or your spouse pass away early? Well, there's great life insurance benefits. There's even some life insurance that has long-term care built into it, so that if you have to go to a nursing home at the end of your life, you can use part of that money to pay for it. Um, there's term insurance, whole life, permanent, IULs, all kinds of vehicles that are going to help mitigate the risk that you might become disabled or pass away too quickly. There's also, disability income protection that we can help with, all of those kinds of things. We help manage your assets. Now, we at Consolidated Planning Group use third-party asset managers, and they do a fantastic job for our clients. Let's see, transition planning. Of course, there's some big transition periods in your child's life that you want to plan for and think about. There's the high school graduation, the turning age 18, and now your child is an adult in the eyes of the law sometimes, which we'll get into with Allison. And there's two more big transitions that people kind of, I wouldn't say forget about, but maybe don't think of it right off the top. And that's when the child moves out of the parent's house into whatever situation they're going to go into. And then the transition period when the parent passes away. That's a big time for the child, and big emotions to have to deal with. We can help you set up an ABLE account and understand how to use it. We help advocate through resources and sharing the information, like I said, and telling you, who do you go to for the questions and concerns that you have? What resources are available to you as a parent? We can help you think about funding sources. How are you going to pay for future care for your loved ones? It's a lot of money. And you have the benefits of SSI and Medicaid, SSDI, Medicare, the waiver programs. You need to use those to the best advantage so that you can afford care for your loved one. And then, we also help you figure out your Social Security. So when you turn on your Social Security retirement benefit as a parent of a loved one with a disability, we want you to really maximize that benefit, because not only do you get your retirement benefit, but your spouse and your child may also be eligible for benefits, and we can help you make sure you all get the most that you possibly can. We tell you when to turn on those benefits, how to turn them on, and what additional programs there are for your family that will be able to help. So these are all of the things that we, as a financial planning firm focusing on special needs, can do for you. Now I'd like to turn it over a little bit more to Alison Packard, because I know if you've seen some of our webinars, you've seen me talk way too much already. So now it's time for Alison. Tell us about the legal side of things and what you do.
Okay. Well, yeah, what lawyers are doing is pretty much getting to know the family, your particular situation, and then often we are preparing legal documents for you. For purposes of this audience, obviously, it's going to be a lot of estate planning documents, wills, trust, most likely a special needs trust or two, deeds. There's lots of different legal documents where we can help get a plan in place so that your assets will pass where they need to go upon your death. Sometimes we're in the court system with guardianships, probate matters, and then generally we're just giving you legal advice, applying the law to your particular situation. So I'll explain to someone, for example, where their assets will pass if they do not have a will. I can take the law of Texas and show you that this is what the state of Texas will, force where the state of Texas is going to tell you your assets need to go if you don't have a will. And so we just talk about different options and apply the law. Um, I will draft a lot of documents, and let me just piggyback off of what Michelle was saying. I'm also the mother of a child with special needs. She's 31 years old, and so I've been doing this a while, but I will tell you, it is a worry to me. Do I have everything ready? Do I have enough money coming into her trust when I pass away and my husband passes away? And so I really love the idea of working with a financial planner that understands special needs, because there's just a different analysis when you have a child with special needs that you're concerned about. We need to look at those Medicaid waiver programs. What kind of support will that be? Will it not be? Understanding how to figure out the amount of money that needs to go into the trust is really important. And this idea of looking at Social Security benefits, if you work with a financial planner that understands special needs, they're going to give you a completely different analysis. Because as Michelle alluded to, for a lot of us, when we draw our own retirement, our children with disabilities can sometimes start drawing benefits off of our work records. So working with a financial planner that understands those angles is really particularly important.
Thank you so much, Allison. And yeah, I forgot to mention that, out of the entire United States, there are over 263,000 financial advisors out there, but fewer than 200 of those focus on special needs planning. And it's really important that you have an expert who knows what they're doing so that you don't leave any money on the table, you don't mess up your child's benefits. And the same goes for attorneys. Not all attorneys are created equal. Maybe your next door neighbor is a real estate attorney, and that's great. And maybe they know a little bit, but you certainly wouldn't want to rely on them for guardianship because, even if they're going to do it free, they're going to possibly mess things up and make mistakes that you're going to have to spend way more money correcting than you would have spent in the first place just by having somebody who really knows what they're doing, right?
That's absolutely right. The biggest place I see this come up is with estate planning. A lot of times someone does a will that won't be properly executed and we have a problem probating the will, or perhaps you have somebody who finds an old special needs trust and they try to use a template and it doesn't work for your particular situation, or maybe they use the wrong type of special needs trust and as a Medicaid payback provision when we didn't need that. They don't give the proper advice on submitting the trust to Social Security or Medicaid. So I agree, especially in the world of special needs estate planning, it's good to work with an attorney who understands those particular issues. Let's see. This slide talks about what the attorney does. The first bullet point here analyzes your personal circumstances in relation to Medicaid and Social Security regulations. What that's referring to is, a big part of our discussion is going to be what government benefits are likely to be available to your child. I'm going to assume we're talking to parents of a child with disabilities, or if it's you, what government benefits will you have available to you? And we'll look at the difference between SSI and SSDI, Medicaid and Medicare, Medicaid waiver programs, QMB, SLMB, SNAP food assistance. We'll look at all of those programs and try to determine which benefits you think will be there long term and which ones maybe you're not thinking of now but could be needed in the future, maybe a nursing home Medicaid. And so as we analyze those things, it gives us a good context of what kind of plan to put in place. For a lot of families like mine, if we have children with special needs, we are uncomfortable a lot of times letting our kids just get an outright distribution of assets when we pass. At least I am for my daughter. I know that regardless of her government benefits, she needs help managing any money that I leave for her, any property that I leave for her. So I know I need a trust for her. Since I'm going to create a trust, I would then look at, do I need a special needs trust? And oftentimes with the families that I work with, we err on the side of special needs trusts because the money in a special needs trust will not count as assets for purposes of determining eligibility for those types of needs-based programs like Medicaid, SSI, SNAP food assistance, etc. So we tend to talk about the options of different trusts, and usually we land on a special needs trust, but not in all cases. So those are the different options we cover. We consider ABLE accounts, first-party trusts, third-party trusts, and then of course the other more traditional revocable living trusts and things like that. This is a slide that just says a general overview of what estate planning really is. It is planning for the transfer of your wealth and your assets upon your death. It's also a plan for managing the assets while you're alive, but if you have disabilities. And so both of those aspects are important. That's where we bring in powers of attorney, maybe a living trust with a trustee to manage assets. So we do want to, of course, focus on what happens when we die, but we also focus on who will manage the assets if we lose capacity while we're alive.
Now, do you happen to know? I know that there's a statistic out there, and I think it's something like 55% of people become disabled before they pass away. Do you know if I'm on track with that statistic or if I'm
I
wrong?
don't know the number, but it rings true to me. It sounds right. I just don't know for sure, but I think I've heard something around that range as well. It's
Yeah.
just very common that even though we're healthy today, many things could happen. It could be the dramatic accident, the car accident that leaves us disabled, but it could also be dementia, Alzheimer's, some of those diseases related to aging. It could be cancers that leave us incapacitated. So there's a lot of reasons why this is a little sobering, but why a lot of us may end up with incapacity in our later years. So it's good to plan for that.
Yeah, exactly. Some of our webinars are fun and funny. Sometimes we have to be serious.
Yeah, yes. And so, a big part of what I will do as an attorney working on an estate plan is spend time with my clients figuring out where they want their assets to go when they die. And I always remind them that if they have what we call non-probate assets, that's an asset where you've named a payable on death beneficiary or a joint account owner. Those assets are going to pass according to the documents that have already been signed. Now, they're very easy to change. So, for example, if I have a life insurance policy and I've said if my husband's not alive, give it to my children, that means my daughter with disabilities will get a share of that outright in her name, which I don't want. So I go back to the life insurance company and I change the designated beneficiary to be my daughter's special needs trust, at least for her portion, if that's what I choose to do. So we'll talk about non-probate assets, make sure that there's not something already out there with a 401k or a retirement plan or an investment account where someone is named as a beneficiary outright when we really want the beneficiary to be the trust. Of course, there are also trusts like living trusts that can leave assets to a special needs trust. So we'll talk about the trust option. If you have a living trust, then a lot of times we can avoid probate. Probate is when you take a will down to the probate court and validate it, and we follow the will to decide where the assets go. But if you have assets already moved to a trust, such as a revocable living trust, then those assets will pass according to the terms of the trust document. So we'll discuss those issues. And then, of course, your standard, excuse me, a standard will. A will is the document where we identify an executor to manage our estate after we pass away. There's different names for that in different states. That's what we call it in Texas, might be a personal representative. But you'd want to know what your state specifically recommends in that area. For example, in Texas, where I am, we want an independent executor to keep the costs down. Independent executor means we don't have to go back to court to get permission to pay the bills, to sell property, to distribute assets. And so we talk about those issues. And then if we have a will that is probated, the executor will read the instructions in the will to determine where the asset should go. So this is a big part of special needs estate planning is updating wills or creating wills where assets are left typically to a special needs trust and possibly other children or wherever you want your assets to go. If you do not have a will and you pass away without that will in place, and you have a child with special needs, it does get complicated. And so I usually spend some time making sure everyone understands the seriousness of that. For all of us, regardless of whether we have kids with special needs, if you pass away without a will, you end up, if your assets don't have designated beneficiaries and don't pass automatically, you end up in court with an heirship determination. That's a situation where an attorney ad litem is appointed by the judge to do an investigation of your heirs. Even though everyone might know who the heirs are, you need that attorney ad litem to do the investigation, and the judge will apply the law and issue a judgment declaring heirship. So basically, you're paying for two lawyers, your lawyer plus the attorney ad litem, so it gets expensive. And then an administrator is appointed to distribute the assets according to the heirship determination. And sometimes, unfortunately, that is the way the law applies may not be the way you wish your assets to go. In my case, as I already mentioned, I don't want my daughter with special needs on government benefits to receive assets in her name outright. I want everything to go to her trust. And of course, the heirship determination would not leave anything to a trust. So then that leads to more legal fees.
Yeah.
And that's where an administrator applies to the judge to possibly modify or to possibly move money to a special needs trust. There's different ways that we can handle that. But oftentimes, once someone receives benefits outright, to transfer their funds to a special needs trust, we typically need to use a first party special needs trust. That, and we'll get into that in a minute, but that's the particular type of trust that has a Medicaid payback. So, takeaway from this slide, I believe that if you have a family with a loved one with special needs, you should have a will. If your will is not done quite right, it is possible to modify a will. You can also modify a trust, but that's a bunch of legal fees. So if go to somebody who understands these issues to begin with, and then you could get your special needs trust incorporated into your revocable living trust or the will.
How often would you recommend that somebody kind of looks at their will or has an attorney look it over for revisions or anything that needs to be updated?
So some attorneys will recommend every 3 to 5 years, and that's fine. I generally say based on life events, that's when you definitely need to look at it. For example, if somebody passes away, if there's a marriage, if there's a divorce, that's a big red flag time to review my estate planning documents. Otherwise, every few years, if you want to just check, and you can check in with an attorney and make sure that there haven't been changes in some kind of Social Security law or Medicaid law. They're not common, but it's a good idea to check in every few years, and for sure when you have a major life change.
Thank you.
So this slide is just kind of emphasizing the difference between a typical estate planning attorney and a special needs estate planning attorney. And I've already been kind of rolling this into the last slides. But yes, we're just going to look at how we can make sure to protect any government benefits that may be needed, or even if government benefits are not needed, how we can provide a system with a fiduciary to manage assets for someone who needs some help. And again, that's typically a trust, but we'll look at those types of assets and draft the appropriate documents. Sometimes we talk about guardianships. Guardianships are not required for everyone, but for somebody who has significant disabilities, perhaps a guardian is going to be needed. So we'll talk about successor guardians and when the right time is to apply for a guardianship, if we think one is going to be needed long term. This slide just talks about your standard, typical estate planning documents. I think I've already referenced these: a will, a trust, a deed, powers of attorney. I always recommend a durable power of attorney to manage finances and give someone the opportunity to talk to the credit card company or the water company if the owner of the home loses capacity, or the owner of the bank account cannot pay their own bills. We need somebody appointed to manage those assets. Medical power of attorney is naming somebody to make medical decisions for you if you're unable to make your own decisions. HIPAA authorizations authorize someone to talk to the doctor, get your medical information. Living will or a directive to physicians, that's a document where you can give more specific instructions about how you want to be treated at the end of your life if you have a terminal condition or what Texas refers to as an irreversible condition where you're unable to care for yourself and you're requiring some life support or some kind of life-sustaining treatment. There's also documents where you can identify who you want the guardian for your child to be, or even who you want a guardian for you to be if a guardian is needed. Guardian designations for children should also be included in wills. And let me just go back up and touch on deeds. Deeds, you can deed your property to another person while you're alive, but a lot of times it makes sense to have that deed go into place at the time of your death. And there are lots of different deeds that we can talk about. Two really important ones for purposes of Medicaid eligibility would be transfer on death deeds and ladybird deeds. Those are deeds where you keep your home in your own name, but upon your death, your home passes to the individuals or the trust that you've named in your ladybird deed or your transfer on death deed. And so those are sort of your common documents that we will discuss. For special needs families, these are the big tools that we have to work with that really are lifesavers for families like mine and a lot of you on this call. Special needs trust. This is huge. These are special trusts that are available to individuals with disabilities. So to be a beneficiary of a special needs trust, you must be disabled, have some sort of disability, or that trust is not available to you. Also, ABLE accounts, and Michelle already mentioned earlier that Consolidated Planning Group helps with this. ABLE accounts are online tax advantage savings accounts, and they're available for individuals who are disabled before the age of 26. Beginning next year, it will be for anyone who's disabled before the age of 46. And those are tax savings plans similar to 529 college savings plan. The money in there grows tax-free. And it's a great way to save some money for someone with disabilities. The funds in the ABLE account do not count for purposes of determining eligibility for Medicaid and SSI. And again, as a reminder, for a lot of these programs, there is a very strict limit of $2,000 in total assets. Now that's the number for Texas and most states. There are a few states that have a higher number, but for most of us, we're looking at $2,000 total assets. There are going to be some exemptions to that, such as big exemptions, such as a home and one vehicle. But generally speaking, when we're talking about cash, we need to keep all assets below $2,000. The money held in the ABLE account will not count against that $2,000 limit. The money in a special needs trust or property in a special needs trust. A trust could hold a home, things like that. An ABLE account, of course, only holds cash, but those assets will not count towards the $2,000 limit. I will say, I don't want to skip this part, an ABLE account has limits on how much can go into that account every year. Currently, it's $19,000 per year. Unless you're disabled and you are working a job, then you get a little extra money, about $14,000. Have to check that number, but you get a little extra money.
The number is $15,560, but
there we go.
only as much as you make up to that. So if you only make $5,000, you can only put in $5,000 additional.
Great. Yes, thank you. So if the beneficiary or the owner of the ABLE account is not working and someone else is donating, such as I'm donating to the ABLE account for my daughter, then currently I'm limited to $19,000. And here's the big thing on this ABLE account. If you are a Texas resident, your ABLE account has a Medicaid payback connected to the ABLE account. That means when your child dies, Medicaid is going to take the funds from that account to reimburse for Medicaid that was paid over your child after the ABLE account was established. Okay, that is different from special needs trust. So a lot of times what a special needs estate planner will do is sort of compare all these different tools to find the right tool that will work for you. If it's a trust, which often it is, you would want an attorney to draft that trust for you. My light just went out. Sorry about that.
Yeah.
And there are two kinds of trusts. I don't know if that's our next slide. Michelle, do you want me to get into that now?
Yeah, well, I just want to say a couple things. First of all, it is starting to storm here real bad. So if my internet should happen to go out, I would be happy to restart the webinar, but I want to warn you that that's a possibility. The other thing I want to say is that, yeah, with the ABLE account, there's a $19,000 limit this year. And then overall, you never want that account to go above $100,000. That's the Medicaid limit on your ABLE account. Now, these two different kinds of accounts, the Special Needs Trust and the ABLE account, work well together because there's limits on what the special needs trust can pay for, but there's no limit on how much you can put in. Whereas with the ABLE account, it's kind of the opposite. There's a limit on how much you can put in, but not much of a limit on what you can use it for. So they work hand in hand for different purposes in different situations.
That's an excellent point. And I do have an ABLE account for my daughter as well as special needs trust. And I think that's often a really great strategy for a lot of us. A special needs trust, the difference between a special needs trust and maybe your typical revocable living trust, there's many different kinds of trusts, but that's probably the most common type of trust. The difference is for special needs trust, the beneficiary must be disabled physically or mentally. And then this trust is going to have a lot of control, a lot of restrictions on the beneficiary's control of the trust. That's a better way to say it. So for example, a special needs trust is going to say that the beneficiary cannot be the trustee, they can't fire the trustee, they can't replace the trustee, pick a new one, they can't demand distributions from the trust. This kind of trust is what we call a purely discretionary spendthrift trust. That means that it is going to be up to the trustee to decide how the money is used. And so this is not the kind of trust where we have budgets built in. There's some other very specific rules of this kind of special needs trust. You have to, if the money is invested and it's growing, the income has to be rolled back into the trust rather than distributed outright like you see in other types of trusts. So because there's a lot of restrictions in this kind of trust, for some higher functioning individuals with disabilities, they might not like that aspect, but this is the only kind of trust you can use if you do not want the funds or the property held in trust to count as part of the $2,000 resource limit. And there are also certain streams of income that you can direct to the trust where that income will not count against the beneficiary. Here in Texas, I'm in San Antonio, we have a lot of military members. Military SBP can be directed, assigned to a first party special needs trust, and the income doesn't count, which allows many individuals to keep Medicaid benefits, Medicaid waiver programs, that kind of thing. Also, child support. If there is a family situation where there's lifetime child support being paid, it's possible to get a court order assigning child support to a first party special needs trust. And then that payment of child support will not count as income to the adult child with disabilities. Again, certain language that needs to be in these trusts, but the general rule is this trust is designed to supplement and not supplant government benefits. It's not a support trust. It is, again, purely discretionary spendthrift trust. Spendthrift means that if creditors come after the individual with disabilities, they have no right to get into the funds of this trust. It's protected from creditors.
That's really good to know. I was not aware of that. We do have a quick question in the chat box that I want to answer real fast. With the ABLE account, does the money grow over time? Yes, it does. In most ABLE accounts, that money is used to purchase mutual funds, which grow over time. And then the income produced by that investment is not taxed. Now, if you've put in $99,000 and the interest comes in and pushes you over $100,000, yes, you could be penalized. So you need to keep an eye on that. What I feel like a ABLE account should be used for would be like the savings account. You know, I have a checking and a savings account at Chase Bank, but if you can only have $2,000, you use your checking account for the $2,000 and under, and then let the ABLE account act as your savings. When you need more in checking, you pull it over. When you have additional money in your checking account, you send it over to the ABLE. And then, you're meant to be using it. It's a save to spend account. It's not like a retirement savings where you want to set aside the money and leave it for 40 years. It's not the same thing.
I think that's great. Also, I'd just add, we talked about all these restrictions on special needs trusts. Sometimes an ABLE account allows an individual with disabilities to have a little more independence and autonomy. So I like that angle of it. If, maybe I said we can't set up these trusts to have budgets and give our kids with special needs their own power to control the funds, but we can transfer money from a special needs trust to an ABLE account, again, limited by the annual limits, but that would allow somebody to have a little more independence, and they can get a card connected to the ABLE account and have some more freedom on that. Um, I thought of something else, but it just left me. Okay, maybe it'll come back. Okay, let's
Yes.
let's go on to the first party special needs trust. There are two kinds of special needs trust, and it's important to understand the differences. A first party special needs trust is the kind of trust, the main thing to remember is this one has a Medicaid payback provision. That means when the individual dies, the beneficiary of the trust dies, the trustees got to contact the Medicaid agencies for every state where that beneficiary has lived over their lifetime and get the reimbursement amount, and the remaining funds are used to reimburse all of those states. Now, if there's no money left in the trust, then there's no reimbursement, or, say there's only $10,000 left, but hundreds of thousands of reimbursement. Well, there's only 10,000 to pay out. But, and if you have more in the trust than the reimbursement, then you just pay the reimbursement amount. But this is a really important point that we've got to remember, because a lot of our kids end up on Medicaid waiver programs, and these Medicaid waiver programs come with a humongous Medicaid payback on a first party special needs trust. Okay. But otherwise, these trusts are available for anyone who's disabled before the age of 65. So this is not available to somebody who became disabled in their later years of life. And the trust needs to be established by a parent, grandparent, guardian in the court system, or a court could actually set up the trust, or someone who has disabilities, but intellectually they are very bright, they're competent to set up their own trust. It's possible for them to do that with their own trust. The assets that could go into this trust are very unlimited. It could be cash, it could be stock, it could be real estate. As long as the trustee agrees to manage those assets, then that's okay. It's unlike the ABLE account where you're limited to cash. But again, I mentioned earlier, some income can be assigned to a first party trust, such as child support payments, military SBP payments, but not all income. So just because you can do it with some streams of income, it doesn't cover civil service pension, through the FERS program, doesn't cover everything. You can't have your SSI directed to a special needs trust and not count the SSI payment. Third party special needs trust. This is where we estate planners, special needs estate planners, get excited, because this is where we can set up a trust to receive our assets upon our death, and there's no Medicaid payback provision. So the difference is the third party trust, the money never goes to the individual with disabilities. It goes straight to the trust. Once the money flows to the individual with disabilities, they can't use a third party trust. They have to put their money in a first party trust. So this is where we're doing the advanced planning, and we are, I'm leaving maybe a house for my daughter to live in when I die, maybe some cash in the trust to manage the house, or maybe just cash to provide her with more opportunities to do fun things after I'm gone. And I get to say who gets the remaining funds when my daughter passes away. So in my case, it's going to my other children. If any of them die before her, to their children, so I can leave it to a nonprofit organization. It's completely open. I don't need to reimburse Medicaid with those funds. But again, this kind of trust only works if you do the advanced planning. This slide is reminding me to mention that if your estate plan doesn't leave assets to a third-party special needs trust, there are some states, including my state of Texas, that allows the judge to reform a will or a trust. That only works for wills and trusts. I think I already mentioned this. You can't go reform a life insurance beneficiary or a payable on death beneficiary on a bank account. For those assets, what you would do is move the money to a first party trust instead of the third party trust, which means you have that Medicaid payback. Now, this gets complicated. This is another push for estate planning. If the beneficiary of those assets is under a guardianship or just doesn't have the capacity to manage their money, then a lot of times it involves going back to court. Sometimes we have to create a guardianship of the estate where only a guardianship of the person was in place to get permission to transfer money to a first party special needs trust. And in many courts, it means you'll be doing an annual accounting of the trust for the rest of the beneficiary's life. So it is potentially huge legal fees if the plan is not in place.
Yeah, so not only do I have a big storm, but I have two guys outside with leaf blowers trying to blow leaves in the storm. So that's why I've been muting myself. But we do have a question in the chat box that says, you know, if I need a will and things for myself, and then I also need special needs trust and things for my daughter, and I need planning for my daughter, should I go to the planner or the attorney first? And I'll let you answer, but my answer would be, whichever feels more comfortable for you is fine. I don't think that it has to be done any specific way unless you are in a specific phase of life. Like if your child is, needs guardianship, they're within 6 months of turning 18 and you really want to make sure they get guardianship on time or right when they turn 18. Or, maybe SSI benefits is more pressing for you when your child turns 18 and you want to make sure that you know how to apply for those. So maybe you want to talk to the financial people first. It could go either way. What do you think about that?
I agree with that. A lot of times we finish with a trust, we get it executed and signed, and then my clients go visit a financial planner to figure out how much money should go into that trust. Um, but if they've already been to the financial planner, they might already have that idea. The only difference I would say, if you visited with the financial planner, maybe you know more specifically the terms of your will as far as how much you want to go into the trust, but it's very, very easy to modify a will. We can create a new one and it replaces the old one. You can do a codicil, which is an amendment. So if you go to a financial planner and you think, I think I need to leave a little more, very simple to come back and change that.
That's true. And another thing, as being members of the special needs community, we keep lists and we keep track of great attorneys who actually know what they're doing and know what they're talking about. So if you don't have one in mind in your area, you might want to come to us first and we can refer you as part of your financial planning, refer you to an attorney nearby you who actually knows about special needs stuff. So we do work together, the advisor and the attorney. Uh, kind of, but we rarely, it's weird because sometimes people will say, "Oh, do you need to talk to my attorney?" Not if they know what they're doing. Right? How often, Allison, do you talk to the financial advisors?
It's just case by case basis. I tell my clients if they want their financial planners involved, they can know as much as my clients want us to share. They can even come to the meeting if that's what my clients want. But usually that's not as common. And typically I'll work with the family separately. They'll visit with their financial planner without me.
Yes, exactly. Now I do
Michelle,
want,
oh,
yeah,
sorry, I
no, go
interrupted
ahead.
you, but can I go back to the Able account? I knew there was something I wanted to mention and I was really racking my brain. I just want to point this out. Able accounts are also very valuable if your child is getting SSI and they're not getting the full amount of SSI. So in 2025, the full amount is 967 a month. Well, there is a penalty called in-kind support and maintenance for individuals receiving SSI who live at home for free, who have a trust paying for their housing. And it's a funny rule, but if they live at home for free or the trust pays for housing, their SSI is reduced. If
Yeah,
an ABLE account pays for the housing, there's no reduction in benefits. So I just wanted to mention that's another good use of an ABLE account in some situations. So just want to throw that out there.
Yeah, we always recommend that our clients send their Social Security office a rental agreement or a fair share agreement or something of that nature. We usually say 500, 600 bucks is plenty to pay for, to say you're paying for room and board. You have to actually transfer that money from the child's account to the parent account to show that paper trail. But once it's in the parent's account, really, you can do anything with it. You can put it into the ABLE account, you can spend it on your child, you can spend it on groceries or anything that you need. Once it's transferred to the parent, they can do anything they want with it. So Allison, if somebody's son, hi Linda, is 13 years old, do you think it's too early to start opening these accounts?
Definitely not. It might be that you're doing it many, many years before you needed to, but it's certainly the safest approach. Basically, you need to have these documents in place and your plan in place before you die. So if you have a 13-year-old son, you probably have many, many decades to get it done. But they're certainly the safest way to go about this is just get it in place. Maybe you're doing it very early, but you can always change it over the years if you need to, and you can be comforted that if there was an unexpected death and so, and we needed to implement the plan sooner than everyone thought, at least it's in place.
Right, right. You never know when exactly that day is going to come, so it's better to be prepared. So there is also a question, Allison, what are some options for people who don't have many resources? Maybe they're not getting child support beyond age 18. Maybe, the parent isn't working or doesn't have a whole lot of money to spend on these very expensive legal documents. What would you suggest in that case?
So as far as the special needs trust angle, and this happens a lot, I would look at the pooled trust option. In Texas, where I am, one of the most excellent pooled trust options would be, maybe I shouldn't endorse one over another, but the Arc of Texas Master Pooled Trust is a very good option, and the ARCs are available all over the country. There are other pooled trust options, but those are less expensive to get into. You're not paying an attorney to draft the document. However, even though it's a nonprofit organization that is managing your assets in a pool with other assets, so everyone has their own sub accounts, they're still going to charge for that. And the fees, at least for most of these pool trusts, are going to be anywhere from 1 to 2%, typically 1.25 to 1.75% of the total assets. So it's not free, but that is an option to just make sure something is in place. You should understand that the Arc of Texas Master Pool Trust and the majority of pool trusts will not accept assets other than cash. So they won't manage a house. So this is where you look at your individual plan. Are you wanting to leave a house for your child, or are you just wanting to leave some extra money? As far as the other documents, there are some nonprofit agencies in my area, and I think in most counties, where you can get legal documents done for free or at a very reduced cost. There are some forms available, but I don't want to push this too much because I've seen a lot of people have problems by using the forms. If you're going to use forms that you find online, I would go to a really reputable source, such as Texas Health and Human Services, maybe for powers of attorney, the Supreme Court for a will. But again, those documents, the will, for example, that is not going to have provisions for special needs issues. So I don't want to be pushy on that, but there are ways to get some help. And then sometimes there's just volunteer attorneys that will help you either reduce their fees or do some pro bono work.
That's great. Thank you for mentioning that. And as your financial advisor friend, I want to let you know that the Master Pooled Trust, one thing that I don't particularly love about them is that you don't have as much control over what happens with your money in terms of how it's invested, and what you're investing in. So, if you have a small amount, it's okay, it's no problem, and it's way less expensive to worry about. But if you are talking about larger amounts of money and you want control over where that money is being put into the market or individual stocks and bonds versus mutual funds, that kind of thing, then you definitely would want to go with something that gives you that control. I've called Disability Rights Texas Rio Grande Legal Aid, but I haven't found anyone to help, and the fees are so high. So what would you say beyond legal aid in
So
the
that's
region?
really going to be a question for the county that you're in. For example, in my county, I'm in San Antonio. So in Bayer County and our surrounding areas, we have a facility, Morgan's Multi-Assistance Center. It's a resource center for individuals with disabilities. I volunteer at a legal clinic there, and we do some legal documents for free. But that's available to anyone. Actually, that's available to people all over Texas. So we'd have to see what programs are in your county.
Yeah, thank you. Thank you so much. So real quick, there's just a few more slides. This one will take you to all of our upcoming webinars so that you can pre-register for them. And then that way you'll get reminders when the webinar is going to start. And you'll also receive the email afterwards, even if you cannot attend that specific webinar. You'll still get the slides and the link to the recording. This is our entire team at Consolidated Planning Group. We've got 4 financial advisors. It's 2 sets of husband and wife, Allison and Jeff, and then myself and my husband, Andy. And then we've got 4, I call them our ops team, the staff that helps behind the scenes and make sure we're on track and doing what we need to do, setting appointments and all of that. We are members of the Special Needs Planning Academy. Now, if you are in a different state or if you're looking for an attorney or a financial advisor in your area who focuses on special needs planning, you can go to the Academy of Special Needs Planners and search by state and by city to find someone who is nearby who can serve you. Now, Consolidated Planning Group, we can work all across the United States. So if you're listening to me right now in the US, I can help you. Feel free to give me a call directly or email me. We are also National Social Security Advisors, and I am a chartered special needs consultant through the American College of Financial Services. I almost forgot what I was saying there. And finally, at Consolidated Planning Group, we offer a completely free initial Zoom consultation. We want to get to know you a little bit, find out about your family, and answer any burning questions that you have. That's the main goal of this Zoom consultation, is to answer your questions. After I've answered your questions and talked to you a little bit about your situation, I will go into, how we work as a firm, what we charge, what we offer, and how exactly we can help your family. And before people start asking in the chat box, how much do you guys charge? It's a very wide range, so it's nearly impossible to tell you. It can be from $0 to, I think I've seen one at $7,000. It really, truly just depends. Just like any attorney is going to tell you when you ask them a question, the answer is usually, it depends, right? Because it's based on your specific, unique circumstances. So you might as well schedule your free consultation. We don't bite. You're going to meet with either myself or my husband, or maybe Allison. And we'll talk you through whatever questions you have and then tell you who we are and how we do the things we do. So please feel free to either use the QR code. You can call or email the office. That's the information here. Or you can call or email me directly. I'm putting that info in the chat box again. There's also links for our YouTube channel, Instagram, our podcast, and our Facebook on this slide. So I really appreciate all of you for being here, especially you, Allison. Thank you so much for helping us out with this webinar. I hope you all have a great week and that I get to hear from some of you soon if you have any questions. Bye,
Thank you,
everybody.
Michelle. Thanks for the invitation.
Thank you so much, Allison. I hope you all have a great day. Bye-bye.
Bye-bye.